Hi, my name is Alexis Johnson, and I am from AFJ Law Group PLLC. We are a full service law firm based in Rochester, Michigan, specializing in business and other civil litigation. Today, I want to talk about something that is not the most pleasant topic, and that is estate planning. And I get it. Nobody wants to think about when they die or what's going to happen when they die, but it's really important to think about because unfortunately, things can change in a moment's notice. So even if you're young, even if you feel like you don't have a lot of financial assets, it's still something that everyone should be thinking about. And I think especially as we wrap up 2020 to a close, now is a great time for you to think about if you have some estate planning documents already prepared, if those still reflect your wishes. And if you don't, maybe you should start thinking about preparing some. So we're going to talk about what estate planning is, why it's important, and a couple documents that you should really consider preparing if you haven't already, or possibly revisit if you have prepared. So, what is estate planning? I mean, it sounds pretty straightforward. It's basically just the process of anticipating and preparing for the management and disposal of a person's estate at the end of life. And you might think, well, I don't really have an estate. I mean, that sounds really fancy, but actually you do. Everybody has an estate because an estate is comprised of everything that you own. So your car, your home, if you own other real estate, if you have checking or savings accounts, financial investments, life insurance, your furniture or personal possessions, these are all things that are part of an estate. And that's why estate planning is so important because no matter how large or modest, everybody has an estate and all estates have one thing in common. You can't take any of those things with you when you die. So it's important to have a plan in place because if you don't, settling your affairs after you pass away becomes a long lasting, costly, and burdensome impact on your loved ones. Even if you don't have an expensive home or a significant number of financial investments or valuables or anything like that. The reason for this is everything is going to have to go through the court system, or in estate planning purposes, that's the probate court system. And it's just a timely, lengthy, costly process that you should try to avoid if you can. Not only for the financial aspect, but also for the emotional aspect. You know, when someone passes away, the last thing the loved ones want to think about is distributing assets or how things should go. It's really helpful to just have a plan in place where everything's laid out and very clear, makes it easy for everyone, and it gives you peace of mind. So today we're going to talk about just some common documents that you should consider preparing if you haven't, or reevaluate if you have, to make sure that they're reflecting your wishes. The first one we're going to talk about is a will, and most people have heard of a will. It's just a legal document that clarifies your wishes in terms of how you want your assets to be distributed and also how you want any minor children to be cared for. So it allows you to appoint a guardian for minor children. A will is probably the easiest estate planning document to prepare in terms of clarifying how you want your assets to be distributed, but there are some specific requirements, so it is advisable to reach out to a professional for assistance. The contents of a will are typically the designation of what's called an executor, which is the person that's going to act out the wishes of the will. Also, there'll be beneficiaries in a will, which are the people who are receiving the assets in the will. Finally, there'll be instructions in terms of how and when the beneficiaries can receive the assets and any guardians appointed for the care of minor children. Now, again, this is a pretty straightforward process. Most wills contain the same types of information, so it's very template based, but there are specific requirements that if they are not met, the validity of a will can be challenged. So you should definitely work with a professional to make sure you're meeting those requirements and clarifying your requests the way you want them to be carried out. The next common document is what's called a power of attorney, and despite the name, this isn't a document where an attorney has to be designated for the role. It's just called a power of attorney. It's an authoritative document, and there's really two types. There's the financial power of attorney and then the medical power of attorney. So a financial power of attorney basically is a document that appoints someone to make financial decisions on your behalf should you become incapacitated. And so this allows someone to manage your finances, make financial decisions, or pay bills on your behalf during your lifetime. Now, once you pass away, this authority ends. And so that's why you have to look to things like a trust or a will, and we're going to get into a trust in a couple minutes in terms of financial decision making after death. But during your lifetime, a financial power of attorney is really helpful because if something were to happen where you were to suddenly become incapacitated, that document's already there. It allows the person to go to the bank on your behalf, to pay bills on your behalf, to do a lot of things that people aren't ordinarily able to do without some sort of court involvement or authority. And then the second power of attorney is called the medical power of attorney. And in Michigan, this is also called a patient advocate designation. So this is a document that allows someone to make medical decisions on your behalf if you're unable to. And this will include such as removing you from life support, like a do not resuscitate type of order. This usually is going to be a role that is held by your spouse or significant other, somebody really close to you in your family, because it's obviously an extremely important role. Sometimes your health insurance or your family doctor may have you fill out these types of forms, so you want to check to make sure that if you have one already, that it's consistent, because obviously complications can arise if you have multiple designations. So it's something that you definitely want to pay attention to if you have one already in place. But if not, it's something you should consider because, as I said, things can change in a moment's notice, and if you don't have somebody appointed, then it gets a little messy. The last document that we're going to talk about today is called a trust. And a trust is a legal document that allows you, and you would be known as the trustor, to put conditions on how specific assets you own are distributed after you die. And so the person who is carrying these wishes out is called the trustee. The people contained in the trust that are receiving the assets are also called the beneficiaries, like the will. However, trusts and wills are very different, and it's usually advisable to have a trust for a number of reasons. The first being that a trust is very flexible in terms of the time frame. So a will not take effect until you die. A trust can begin working during your lifetime. So there's two different types of trusts. There is a revocable and an irrevocable trust. And basically they sound exactly like what they mean. So a revocable trust is a trust that can be changed throughout the trustor's lifetime. And then once the trustor dies, the trust becomes irrevocable. An irrevocable trust is exactly what it sounds like. It can't be changed at all, even if the trustor is alive. So it's generally advisable to start with a revocable trust, and that way you can have some flexibility, you can make changes as needed, and this may even result in changing the trustee to handle the trust. But it gives you a lot more flexibility than a will. Another thing is a trust affords a lot of privacy. So if there's any discrepancy or dispute over a will, it's going to be settled through probate court, which those documents can sometimes be available to the public. But a trust remains private and it avoids the probate process. So this is usually very attractive to people that have, a high value estate with a lot of assets, or they just prefer, the privacy and they don't want that to become public record. So that's why a trust is usually a more attractive alternative. And trusts are very time efficient because for the most part, trusts avoid the lengthy and costly probate process. And so this allows your loved ones to save time and money and emotional expense dealing with navigating the probate system or litigating. And so it's really helpful in that way as well. Finally, trusts add some protection because they can protect certain assets from lawsuits and creditors. And that is very attractive, especially because things can change so much throughout the course of a lifetime. So if you have a revocable trust, is another benefit as opposed to just having a will in place. So I know I mentioned previously that there are two main types of trusts. and that's the revocable trust, which you can change or modify throughout the lifetime of the trust and then becomes irrevocable upon the death of the trustor. And then an irrevocable trust, which is exactly as it sounds, it's irrevocable no matter what, no changes can be made. And so the main thing you want to think about when you're choosing the type of trust for you is whether or not you want a revocable or irrevocable trust. And there are certain advantages and disadvantages to either. So it's important to consult with a professional to make sure that you understand the risks associated with both and you've come to a conclusion that reflects what you're looking for. So I know that estate planning is not a really glamorous or attractive thought. Nobody wants to think about the end of their life, but it's really important to have a plan in place because you really want to avoid having things litigated in the probate system if you can, not only for the expense, but for the emotional toll that it takes on your loved ones. If you have other questions, please feel free to check out the website afjlawgroup.com. And we will see you soon. Thank you for checking out this video.